With a landmark ruling from the Bloemfontein High Court. In a historic decision, two husbands have won the right to adopt their wives' surnames. And this groundbreaking ruling has sparked widespread debate and is set to challenge traditional gender norms. In fact, yesterday here on the AM Report, we ran a poll, many people saying that the idea of it is absolutely ridiculous. But joining us now to discuss the implications of this decision is Professor of Legal Pluralism, Religious Family Laws and Human Rights at UCT, Professor Waheeda Amien. Prof, good morning to you. Thank you so much for joining us. I wish I could show you that poll yesterday that we ran for our viewers, and one of the options was, that we've got traditionalists as a country, many people saying that it's a ridiculous move. But obviously we'll get your views on it. But I want to hear your thoughts on, just when you heard about the ruling by the Bloemfontein High Court, was this a step in the right direction?
Absolutely, absolutely. I think that it's a progressive decision. It's a decision that recognizes that this was still an instance of patriarchy being reinforced, and that it was a case of unfair discrimination based on gender and sex. And the court said, no, this is something that needs to be remedied. So absolutely, it's a step in the right direction.
Yeah, it's interesting because there's obviously the perception of, well, how is this going to work? We're still such a traditionalist country, and I can imagine just the sort of debate that you've heard around it. But many that I've heard even saying, well, the man pays the lobola, the woman should take the surname and vice versa. So there's a sense that it's a very academic sort of conversation and it's simply not going to trickle down into the greater part of our society.
So I think we need to start with what was the reason for the law to begin with? And so here we're talking about the Births and Deaths Registration Act, Section 21, right? Which says that a woman, whether she's married or divorced or widowed, if she wants to change her surname, she can apply to the Department of Home Affairs to do so. She doesn't have to give any grounds. And usually it's an administrative process where she simply pays a fee, admin fee or application fee, and then she gets her surname changed back to her own, right? So here's the thing. We're living in a society that still reinforces patriarchy in terms of names. So when a woman is born, she takes her father's name. When she gets married civilly, and also then, of course, according to customary law, because those marriages have been recognized, then automatically her name is changed to that of her husband's. And so if she wants to take her maiden name, or rather her birth name, or she wants a hyphenated name, she goes through that administrative process. But the man doesn't have that option. His process is actually more onerous. He's got to apply to the Director General of Home Affairs and show that he has sufficient reasons for his surname to be changed. So in this case, there were two sets of parties. The one set was a husband and wife, where the husband wanted to take his wife's surname. The other set was the wife had decided to take a hyphenated surname, and the husband then also wanted to take that hyphenated surname. And in both instances, the Department of Home Affairs said, no, the law doesn't allow you to do so. They would have had to apply to the Director General and show sufficient reasons for that. And so that's why they challenged it, because, and rightfully, their claim was that it is discriminatory, it constitutes unfair discrimination, it's a reinforcement of patriarchy, and the court agreed with them. But I think one needs to see it within the context of the husband having been regarded as the head of the household. And so his name, the assumption was he would never want to change his name. Why would he want to change it to his wife's name? So yes, I agree that in certain instances where patriarchy is still very much entrenched within our communities, there's probably going to be pushback. But I think that there are sections of our community where men are wanting to take on their wives' names or a hyphenated name. And I think when the law changes, eventually the hope is that behavior and conduct will also change, that the law and the enforcement of the law eventually trickles down. It's not going to be an overnight process.
Yeah.
I think there are certain people that will welcome the decision quite quickly, and in other communities it's going to take a bit longer.
Here's what stands out for me. You've got Mpumelelo Mkhabela, who's written a piece, and it's titled Breaking Patriarchy. The High Court ruling allows surname equality, and he used the word equality in marriage. But what's interesting about the argument he puts forward is when we talk about patriarchy, of course, there's this assertion that we're talking about, patriarchy, I suppose, with its foot at the necks of women and people, and the LGBTIQ community. But what this ruling actually does, it's quite interesting for me, is it almost puts forward an idea that even that idea of patriarchy giving a lot of limitation to men as well, right? And he writes, the rights of LGBTIQ people are constitutionally protected. They include the rights of freedom to choice. In South Africa, the right to abortion is constitutionally entrenched. It's not even part of political bickering, but this issue seemingly will be.
Yes. Well, that's the thing, right? What's happening with this change in law is it's challenging that patriarchy. It's going to one of the core essences of patriarchy, the domain of the man, the domain of the man to have his name and his legacy entrenched within the family and continued within the family. And people, I think people would perceive this law as challenging that right, or that assumed right that society for so long has been has adopted, that the man is the head of the household, the center of the household, who makes the decisions, and the name very much goes to the identity of that man and of that family. And so this law would be challenging that, or the judgment and the subsequent change in law would be challenging that. So I completely understand that there would be pushback from very patriarchal sections of society.
Yeah, he goes on to write, and this stood out for me, families whose surnames have political or heritage meanings, such as the Mandelas or Sisulus, for example, might soon have new males assuming these surnames, not by lineage, but by marriage to descendant granddaughters. That's a really interesting take on it, right? But talk to me about I suppose the steps that need to come, because we're talking here about challenging the Births and Deaths Registration Act. Is he talking about a policy and legislating change? And that's quite a long road, right?
Yes, absolutely. So what the court did was, because it needs a change in the actual legislation, the court gave the state 24 months to remedy the gap in the legislation to enable men to also be able to go through the same process that women go through to have their names changed, and not have to apply to the Director General and have to show sufficient cause. So men now, when the law changes, a man will also have the same right to simply go to Home Affairs, fill in a form and say, I want to change my surname, pay the admin fee, and then Bob's your uncle.
Yeah, interesting. You've got the Free State Society of Advocates having joined the challenge as friends of the court, and they've argued that restricting a man's right to assume their wife's surname violates the principles of gender equality. And this is going to be quite the discussion, because we're going to open it, obviously, at some point for public debate and contributions from the country. And perhaps things might turn around there. But I think the lessons that we take from this around how we constantly need to be looking at our legislation and what it says for equality across the board in the country.
Yeah, look, I think the important thing to keep in mind here is that what the judgment is essentially saying, apart from the fact that the status quo has been discriminatory and reinforcing patriarchy, the judgment is saying that both parties to the marriage should have the right to choose what their surname should be. And you know, you shouldn't have to go through a marriage having a name imposed on you. That you should be able to make that choice. I actually think we need to go one step further. You know, I think, in fact, and I hope somebody will take up the cudgels of litigation in this sense, and change and apply to change the law so that when parties get married, one person's surname is not automatically changed. Because that's an imposition, right? When a woman gets married, her surname automatically changes to that of her husband, and that's part of the reinforcement of patriarchy. She should have the choice to say, okay, I want to take my husband's name, so I will go to Home Affairs to get it changed. She shouldn't have to go to Home Affairs to change her name back to her birth name and then pay an admin fee for that. I mean, that's completely ridiculous. And so I am hoping that we're going to be moving to a situation, and I hope that, you know, someone from Home Affairs is listening to this, that in fact that automatic change of surname needs to be done away with. That when parties enter marriage, they should retain the surnames they're entering marriage with. And then if they decide they want to change it, then go through the administrative process of having to do so.
Yeah, perhaps a conversation we should take up with the Department of Home Affairs. Prof, thank you so much for speaking to us. It's such an insightful conversation. Professor Waheeda Amien of Legal Pluralism, Religious Family Laws and Human Rights at the University of Cape Town.